Waiting on defense counsel on White. All right, then we have copies of the defendant's motions. Yes.
We got, before y'all get started, if you gotta use any electronic, we have to discuss outside. We don't want any text messages, phone calls, recording, or filming while the proceedings are going on.
Thank you, Deputy. All right, we're back on the record. The record will reflect that the defendant is present with his attorneys. The state is present. And the defense has delivered its pretrial motions. Has the state had an opportunity to review those motions?
Yes, Your Honor.
All right. I'm going to go in the order in which it was handed to me. So let's start with the defendant's motion for list of state's witnesses prior to trial. Has the state given a witness list?
We have not yet, Your Honor, but I will have it to the defense in the next few days. I'll be working, finishing it over the weekend.
Okay, by Monday. We should hand it over by Monday. That motion is granted. Defendant's request for notice of state's intention to use evidence of extraneous offenses at trial. Has the state had an opportunity to review that motion?
I'm sorry, Your Honor, which one was that?
The 404B, 609, 36, 707, 3837, that extraneous.
Yes, Your Honor, the only two things that we'd have on the 803, 804, 902, since these are hard copies.
I'm not sure we're looking at the same motion.
Got a commercial driver license and need a job? Check out ZipRecruiter. Find driver jobs with great pay and the right schedule. Set up alerts to know when new jobs are posted. Upload your resume and apply with one tap. Find a better job with better pay on Zip.
I will put that into the second page. As far as the priors, they are, of course, physical copies. And so if they want to schedule time to come inspect the physical copies of the priors, the certified priors, I'm happy to accommodate them.
Okay, Ms. West, can you do that on Monday? This is Friday. Would you like to do that on Monday?
Let me see. I'm sorry, Your Honor, I'm naturally in Dallas County on Tuesdays, so I'm always here Tuesday, usually Mondays, Wednesdays, and Thursdays I'm in other counties.
Okay, I'm ordering the state to make these available to you at least by Monday, so you can get with the state and determine whatever of the dates would be convenient for you, but the state will have it ready for you on Monday.
They're ready.
I'm sorry?
They are ready, Your Honor.
Okay, very good.
The next thing would be,
Let's put a date on Monday. Monday would be the 27th.
the one exception that I know that is not ready, and we're just waiting on getting it, is the defendant's federal prior from the Eastern District of Texas, and we are working on obtaining that. So that is the only one that we do not have back yet. once I have that, though, I of course will accommodate to let Ms. West and her team come look at it. The only other thing I had as it relates to this motion is the 20-day notice. I believe the code asks for 10-day notice, but we will be filing our notice of extraneous on everything on Monday, and be providing that to defense via e-file.
Okay,
However, since there is a 20-day requirement on there, in case there were jail incidents or anything that came up in between the 20th date of trial, I just want to make sure that anything inside those 20 days that becomes known to us, any new events that may or may not come up, that we're not restricted just because of that 20 day.
you will not be restricted.
Thank you, Your Honor.
And Your Honor, could I ask whether or not the state, obviously they're gonna e-file everything, which I think is appropriate, but if they would be willing to also send an email, just because there are a gazillion
Right,
things that are e-filed.
And that's been my practice on every single motion I've filed on this.
okay. Motion to require state to reveal agreements. Has the state reviewed that motion?
I have, Your Honor, and again, we just talked about this previously on Mr. Conway's case on the record just a second ago, or an hour ago. As it relates to any deal by the state, at this time, Your Honor, there's no deal between the state and any witnesses or co-defendants. Of course, I would make all defense attorneys and all defendants aware of any deals as it relates to any agreement or any law enforcement agency. I am requesting that information from the federal government and their prosecutors. If I get a response or receive that information, I of course will pass that along to the respective parties. However, that's not my possession.
All right, that motion is granted. Motion for discovery of the arrest and conviction records of state's witnesses. Has the state reviewed that motion?
Yes, Your Honor, and again, we took this up briefly, again, on Mr. Conway's, and it's part of the agreed order that I had proposed to all the defense counsel that I would provide them with the NCIC, TCIC text, again, of any witness that I intend to call, and that information, if it were in our possession. Of course, I would do my due diligence,
Okay.
and turn over what we have.
All right, this motion is granted. The state will turn over to the defense any criminal history of its civilian witnesses and law enforcement witnesses, which the state is under an ongoing obligation to discover.
And again, just to be clear, Your Honor, because under number 1 on defense motion, it's asking the court to order us to examine the records of local law enforcement agencies, TCIC, NCIC, concerning arrests and convictions of each of its witnesses. Does that mean the court is ordering us to run each and every witness, including law enforcement, prior to trial, to actually run them?
Well, what I'm asking you to do is to turn over to the defense any criminal history that your law enforcement witnesses or civilian witnesses have.
Correct, and I just want to make sure that, because that is asking what you were saying, but granted, are you ordering us, as in subsection 1 is ordering us to examine the records for every witness?
How would you find out the criminal history of each of these witnesses?
I mean, I can ask them, but I mean, that's what I'm trying to clarify on the record. Are you ordering us to enter every single witness, civilian and law enforcement, into these databases?
All the witnesses that you will be calling,
Correct.
if they have any criminal history, you are to hand it over to the state, however you discover it,
Again, and just
which is what? By running their TCIC, NCIC? Is that how you would usually discover it?
That's what this, her motion.
But I'm
is.
asking you, is that how you would discover it?
We do not run law enforcement through TCIC, NCIC.
Okay, but if they do have a criminal history, how would you discover it?
I can ask them.
Okay, if they do have a criminal history,
Correct.
it's your duty to discover that and hand it over to the defense.
Okay.
That's my ruling. Motion for discovery of punishment evidence.
Your Honor, I'm generally okay with the motion. However, we would object on number 3, 4, 6, 7, requesting the names and locations of any witnesses. That raises the burden of the state and is outside what the law requires of the state to actually provide. Defense has all the discovery in this case. The law only requires the return of the names of the witnesses that we intend to call.
May I respond to that, Your Honor?
Yes, you may.
I do anticipate that the state may call witnesses that they have either provided safe harbor to or are assisting, and therefore there wouldn't be a way for our investigator to locate them, for us to potentially investigate and interview those witnesses. So I would ask that the court grant this motion as written and ask that the state provide us with the locations of its witnesses so that we can investigate independently.
May I respond?
Yes, go ahead.
Your Honor, at this time, there is not any witness that I believe that is under safe harbor or being protected by the state, either the state or the federal government. And if there were, I have a different argument that there would be a reason their location was confidential and being protected. But that is not the case. And again, that is requiring us to do something that is not required by law. I'm happy to provide them with the names of the witnesses. They have all the discovery, which provides even names and phone numbers. However, this asks for more than the law is required of us, and could potentially put a number of people at significant risk.
Right, the state will provide the names and the contact information, phone numbers of the witnesses that they intend to call for punishment evidence. And I mean, if there's a particularized need for the location, y'all can come back to me, and if maybe the state will broker a meeting. Okay?
Thank you, Your Honor.
So this is granted but denied as to locations of said witnesses, unless there's a particularized need and the defense meets that burden.
Yes, Your Honor, and just so the record is clear, even though that portion is denied, you are requiring that the state provide contact information.
Yes.
Thank you.
All right, motion for discovery. Has the state reviewed that motion, that document?
Yes, Your Honor, and I have a number of objections to it. Under subsection A, number 1, addresses is an objection, is my objection, is the same one we just talked about previously.
Okay.
Again, it's,
Court will make the same ruling. List of names and contact information other than addresses, unless the defense makes a particularized need,
Uh,
shows a particularized need.
Number two, we agree with a list of names and addresses as it relates to expert witnesses. However, adding in the professions, the subject matter and description of his or her contemplated testimony and his or her report, I'm okay with the report, but profession and the subject and description of his or her contemplated testimony is not what's required by law.
Does the state have any reason to not want to provide those?
Well,
The profession of, being an
I'm
expert
fine with
witness?
the profession, but me writing down a description of the contemplated testimony, then I'm summarizing what this individual may testify to, and that puts me in the spot of creating a narrative, and I'm not the person testifying. I'm happy with giving the name and address. I'll even throw in profession. However, me
And the
writing,
subject of the testimony, not necessarily a summary, it's a subject.
that's fine. I'm fine with that.
All right.
Number five, it's dealing with criminal histories again of each witness for the state. Of course, the court knows our position on that.
Yes.
Again, on number
So you
six,
have my position on that.
I'm sorry, Your Honor.
You have my ruling on that.
Yes, Your Honor.
Okay.
Again, I believe number six covers that as well. Moving on to these statements, I'm fine with everything up until number 11, which I just want to, 11, 12, and 13, I just want to make sure that it's on the record that we have provided these transcriptions for 11, 12, and 13. I don't have any problem with them. I'm just letting the court know that we have
Provided those.
complied with that. Yes, Your Honor.
And Your Honor, if I may, I just want to, I do know that I have received information as it relates to testimony at the grand jury and things like that. I would just want to make sure that the record is clear that if there's anything outside or in addition to what I've already received, that I want to make sure that that's, that the state is directed to turn that over.
Okay. The state will be ordered to hand those over. I mean, you're
I don't know
under
if
an
that-
obligation. Well, I'm not sure there's been any other grand jury testimony
There's been
Since-
a number of people who have testified, Your Honor.
since.
Yes, there have been
Okay.
a number of individuals who have testified in grand jury proceedings. All of their transcripts and the evidence that was presented in those, if there was evidence, has been turned over.
Okay. I guess I'm asking if there's been any more since then.
No.
Okay.
Under subsection C, we're fine with everything. Subsection D, again, Your Honor, a couple of these things I'm just objecting to because it's not required by law, and I don't know what some of these are. I mean, as far as the name and rank and badge number, I provide the name and badge number, and it'll be on my witness list. As far as the rank, that's so fluid, that could change, and I might not know what it is. I'll ask everybody what their rank is.
Name and badge number would suffice.
Thank you, Your Honor. The name and address of any person, including suspects in this case. So again, this is why I think the address thing is this is right on point, and I appreciate this being here. Like, it'd be like me providing the name and address of where defendant Conway is currently staying. I am sure Mr. Shook and Mr. Guscio would have a huge objection if I were to provide that to other defense counsel, the actual address of where he's living. I'm sure he doesn't want it out there. So again, we're objecting to the address portion of number 3.
That's sustained.
And as far as phone numbers or contact information, I can't really get a contact number for co-defendants and stuff. I mean, I could ask Mr. Shook to give me Mr. Conway's cell phone number and I can provide it to Ms. West, but
And I think, Your Honor, the way that it's written is I'm asking for suspects, which are different than co-defendants. And so I would be asking for, that's what we're asking for. And I assume that the court's ruling is going to be no addresses, just contact information.
Correct.
Yes. That, we don't have an objection to that.
And also, Your Honor, as far as requiring us to provide the name and address of any person, I'm happy to provide the name and contact of individuals I'm planning on calling. There's individuals that I'm not planning on calling. Again, goes way beyond the scope of what's required by law for me to track down all these people. I mean, they have an investigator, they can do their due diligence on a case too. As far as the individuals I'm intending on calling and the information that I have, I will provide it to them. I have no problem with that. But to make me say any potential person in the world, that would be.
Well, and I apologize, I don't mean to cut you off, sorry.
I mean, they have to do some due diligence on their own as far as witnesses, as far as who I'm going to call and who I'm planning on putting on the stand, I will provide that information.
Okay.
And Your Honor, it's just, it's not any person in the world that's associated with this case. It's very specific to interviewed by representatives of the state or law enforcement. But either way, I don't have any problem coming back to court if I'm struggling to locate someone that the state has provided me, coming back to the court to ask for assistance related to that. They have vast resources as the state of Texas, which are far beyond what any investigator that I have is capable of.
All right, otherwise, my ruling on all the paragraphs here that deal with addresses of witnesses, my ruling is that the state should turn over the contact information, phone number, name. But if the defense has a particularized need for the address, then y'all can approach me, or you can sort it out between yourselves, right?
Thank
Okay.
you, Your Honor.
All right.
And those objections, Your Honor, carry on through number 8 of subsection D.
Okay.
Under subsection E,
I don't mean to interrupt, I just want to make sure that I'm understanding. You're saying for part 8, that obviously the court has already ruled they're not going to provide addresses, but are you having an objection to providing the name and telephone numbers of informants?
No, I think he's just talking about the
Address?
Yes.
Thank you, Your Honor.
photographic evidence, defendant under subsection E, defendant moves the court to order us to produce and permit counsel to inspect the following designated items regarding photographic related evidence in this case. On number 1, where it's laid out a photograph, videotapes, audio tapes, drawings, charts, and diagrams made by the state. If I'm making something, Your Honor, it could be my work product and it could be things that I'm using for my own personal preparation of this case. So I would object to anything that I'm making outside of what is going to be offered at trial and for the purposes of an exhibit.
Right, this will not include work product by the state.
For the following E, we have no objection. F, I have no problem with defense inspecting physical evidence. However, they would need to, and I'm happy to put them in touch with Detective Barnes. However, I believe Detective Barnes or defense has his contact information. They would have to coordinate with DPD or the other agencies because we don't house the property here. So it would need to just be coordinated with the Dallas Police Department.
All right, so the defense will make that contact and schedule a date for whatever physical evidence you need to review.
As far as the test results, we provided all the test results, so we have no problem providing them with all test results regarding scientific evidence reports. As far as things that were made by quote unquote experts, we have no objection with any of that under subsection G.
Under H,
Subsection 1, 2, 3. Subsection 1, 2, and 3 would all be, if it exists, it's already contained within the discovery that's been provided. I would ask for clarification on number 4. But the evidence of pertinent trait of character of the alleged victim of the crime, which the defendant is charged, a little, like, I don't know what the defense wants me to say about the victim's character. It seems like an opinion question that I would be giving.
Right. This is something that, if at all, it'll come through testimony.
What this point is asking for is if the state is in possession of evidence related to information that would fall under section 404D as it relates to the victim, if they're in possession of that, then that be turned over to the defense.
What's the state's response?
We provided defense with a large number of ROIs and reports about this ongoing back and forth beef. In fact, we heard evidence of back and forth stuff. I'm going to run the victim's criminal history, even though he's deceased, and that'll be part of the stuff that we have, because I do know it's in there somewhere, I believe. As far as me providing pertinent traits of the victim's character, outside of witnesses who are going to testify to that, I don't know how I would even do that.
Well, I think a big part of what the state is alleging is that, and I think that we heard Detective Barnes talk about an alleged beef between various parties, and that there was a tremendous amount of testimony in that pretrial hearing about the decedent in this case, and statements that he made, raps that he made, referencing firearms and killing people and found all of that kind of thing. And the state is obviously in possession of it because they had a whole hearing about it related to a co-defendant. So it's referencing that type of information. They've already had a witness that has testified to a tremendous amount of information. So that's what we're referring to. We have ordered the transcript in that case, but those are the things that we're referring to.
And I believe the state, they've tendered all documentation and exhibits that would point to this, if I'm understanding you correctly. You're talking about bad acts by the victim?
Right, Your Honor. So I don't know if the state sent me their evidence that they introduced, like, during that pretrial hearing. I perhaps need to search for it. I didn't see where I received that. When I say we ordered the transcript, I don't know if that's going to include all of the exhibits that were introduced.
It was uploaded about 2 weeks ago, Your Honor.
Okay, if you can re-forward it to me, that'd be great.
It's on texture. It's on texture.
Oh, okay.
And as far as, again, getting into the character stuff, I provided what's in my possession. If I'm not going to go out and search down every YouTube blogger who was pro YELLABEEZY and who was anti both three. I provided what we have in our possession.
I'm not sure that it asked for anything other than what's in the state's possession.
Okay. Otherwise, so this number 4, do you want to revise that to read something else? For example, or do you want to withdraw that?
Your Honor, I'm happy to revise it
Okay,
to read, and I don't know if you want me to,
go ahead, recite it.
okay. So we would, that we're asking for the state to provide evidence within its possession of character evidence of the alleged victim in this offense that would or could be admissible under 404A3A of the Texas rules of evidence.
What's the state's position?
I'm fine with that, Your Honor.
I'm sorry?
I'm fine with that, Your Honor.
Okay, very good. All right. Any other comments or objections?
No, ma'am.
All right, that motion's granted. Motion in limine. This one's just titled motion in limine. I think I have a number, okay, well, 2 motions in limine.
Your Honor, I haven't filed my motions yet regarding extraneous offenses, prior convictions, anything, so I'd ask that this be held, and then if we need to take this up at a later time, we can.
Which motion in limine are you holding?
I didn't realize that it doesn't have it.
I have 2 in my hand here. One says, one has another header, prior convictions.
Okay,
Is that
sorry,
what you're looking
the
at?
other one. The one with prior convictions, you want to start on that one?
Yeah, the one that says prior convictions. Okay.
Okay. I'm fine with this one because it's just, they're asking that nobody refer to anything unless a hearing is held outside the presence of the jury. I'm fine with, as it relates to prior convictions. As far as hearing under subsection 2 for specific convictions or alleged violations, again, regarding hearing outside the presence of a jury, I'm fine with that. Extraneous offenses, when we get down to B on page 2. I have no problem not, that these would need to be, like subsection 1 doesn't ask for a hearing outside the presence of the jury. I'm fine with subsection 1 if the defense wants to have a hearing outside the presence of the jury, which is in subsection 2, but not in subsection 1. So I have a problem with that. And additionally, to cross-reference another motion, the defense has also filed a motion to adopt motions, objections, and requests for instructions of co-defendants.
Hold on, I think you're running ahead.
So I also want to make sure that I'm following. Are you under, in the original motion that we were just talking about, under B, which is titled extraneous offenses, and then point 1? Is that where you were just referring to?
Correct.
Okay, so this is just that we're requesting that neither the state, its agents, its employees, its witnesses mention, allude, or refer to any extraneous offense alleged to have been committed by Keywan White in the presence of the jury.
And I understand that, but also every other time, like in subsection 2, or on the previous page under subsection 1 and subsection 2 there, you asked for a hearing. On this one, you did not ask for a hearing, which is different. So I'm fine with that.
On which one?
Subsection 1 of B1. So I'm fine with that as long as it's subject to a hearing outside the presence of the jury.
Yes, so before any extraneouses are mentioned, let's have a hearing outside the presence of the jury.
Your clients dream big. Your agency builds bigger. Base 44. Builds it all. Give your clients what others don't. Unlimited buyer title. Your agency can move faster. Go further. Expand. Build tools wired into your stack. Automate. Ban redundancy. Every skill, multiply. Every hour, worth more. You don't need to reinvent yourself. It's already done. Base 44.
The ruling on certain extraneouses, which, I mean, and so I think that's going to factor into what I will allow and what I won't allow. Yeah, so what was your, what specifically are you
So I
alluding to?
I want to make sure, and maybe the easier way to do it so that we can all be on the same page is once they file any additional notices to us regarding extraneous, that all of the things related to extraneous, our motions in limine, et cetera, can all be ruled on at the same time. So that we all have a clear roadmap about what needs to have a hearing, what is just coming in, and that's all happening at one time as opposed to piecemeal.
Okay, and you do have the notice of extraneouses. You
What I
have that notice,
understood-
right? Oh, you haven't submitted that yet. You
That's,
said you were going to
That's
do
what
that
I'm
by
gonna have.
Monday.
Monday.
Okay, all right. So once you exchange that information on Monday, Ms. West, if you need another hearing to talk about specific extraneouses on that list, then we can schedule a hearing.
yes, and I anticipate we will, so I can reach out to the court at that time. to
Okay.
schedule it.
All right. Okay, so I have another motion in limine. Has the state had an opportunity to review that one?
And again, Your Honor, I wrote a hold on this one because I don't think we can do anything until that's filed on Monday.
Does this still reference extraneouses? Is this the
Correct.
same motion, but just a different format, Ms. West?
What, I was in conference with my co-counsel, what is the motion that you have pulled up in front of you?
There's one with prior convictions as a subheader. But
I'm gonna agree with the state and say, can we hold that? So that we can, again, just, everybody be on the same page about what's gonna have a hearing and what's not.
all right. Defendant's motion to adopt motions filed in prior cause and co-defendant causes. Explain that, Ms.
Yes, Your Honor, I don't know that it's, this is sort of a catch-all. I know that there was a period of time where Mr. Ashford was lead counsel on the original murder charge. I don't know if he did anything. I don't know if he filed motions. I don't know about what may have happened. But because this is based on the exact same set of facts, I wanted to make sure that anything that happened or was filed or ruled upon in that murder charge carries over into this cause number, as well as anything that may have been filed in some of the other co-defendants that were originally charged with murder and then upgraded to capital murder. If the court made any rulings, if there were motions that were filed, because several of these co-defendants were originally charged with murder and were dealing with the exact same set of facts.
Okay, so you want to adopt the court's rulings regarding those co-defendants' motions?
As well as any motions within P1 White's original case number.
Okay, I don't think Mr. Ashford filed any motions, and I don't think the court has ruled on
There's-
any. defense
Just so we're clear, Your Honor,
Mhm.
was that the defendant's motion to adopt motion? So I've got two separate ones on the motion to adopt motions. One's defendant's motion to adopt motions filed in prior cause and co-defendant cases. And I have another one that's motions to adopt motions, objections, and requests for instructions of defense. I don't know which one we're talking about.
We're talking about the one that does not mention objections and requests.
So, okay, so just as it relates to co-defendants, whether or not I have a problem with the co-defendant language because there may be a reason it would be relevant, that the court might find that it would be relevant in this defendant's case, but maybe not in another defendant's case. So I think that in itself, just adopting motions.
Well, if they want to adopt it, I can't stop them.
Oh, sorry, that's the adopting the file of it. I'm fine with that. If they want to file all the same motions, I'm fine with that.
Okay. All right, so that's granted. All right, so the second motion to adopt motions, objections and requests for instructions of co-defendant. Does the state have any comments or?
That's where, Your Honor, I would take issue with a blanket of the court adopting the same ruling as it relates to this defendant as it might relate to a different defendant. So I think that would have to be a case-by-case basis, and court would have to evaluate it case by case.
Well, that, you're probably right, but then I'm not defense counsel. And I can't strategize for a defense counsel. And if that's what they want to do, if they feel that's the best for their case, then the court will grant it. Is that what you're asking for, Ms. West?
Your Honor, and I want to make sure that I'm being very clear. What I am asking is that there be the rulings that come out of the court as it relates to the individual co-defendants, that those be sort of as standardized as they can be. There are specific facts to my client that may be
What do you
different.
mean sort of standardized?
So in other words,
I will only rule on specific motions brought forward by the co-defendants and their attorneys. I mean, I can't tailor make it for you or them. It depends on whatever they bring me. So if
Sure.
you're asking me to adopt my rulings on their motions, then that's what I'm going to do. I'm not going to go back there and say, well, is this going to benefit Keyone White or, not
I'm
do?
not asking the court to do that.
Okay,
As an example, there was an extensive pretrial hearing in Mr. Conway's case regarding the admission of rap lyrics.
okay,
So what this motion is about and what it's asking for is, for example, and I have no idea how the court is going to analyze any of that information, but should the court decide, for example, that rap lyrics are not relevant and they're overly prejudicial and they're not probative, if that's how the court rules, then we would want that same ruling to be able to apply because it's about rap lyrics and not
Okay.
necessarily the content of what's being said.
okay,
That is what this motion is about,
okay.
as an example.
Okay. And I don't see that the state can object to this.
Well, Your Honor, on that general, like, again, that is a general, that is a specific example. This is a general motion.
And I'm treating this as a general motion.
Right, so as a general motion to adopt what would be ruled upon in Mr. Conway's case, we might want to approach and explain to the court or give examples of how something may be relevant. Again, as a specific example of the Conway hearing as it relates to rap, I understand that as it relates to those specific exhibits. As it relates generally, which this motion is, we would need to be heard as far as why things may be relevant in Mr. White's case if the court found that they weren't. in Mr.
Well, absolutely.
Conway's.
During trial, both sides will have to, make their arguments during cross or direct. And, this is just a specific example that she gave. But during the trial itself, counsel is going to have to object and raise concerns regarding whatever evidence the state intends to put in or whatever arises during testimony. Ms. West, that is your understanding, correct?
That is my understanding, Your Honor.
Okay. All right. Motion for disclosure of expert witnesses.
And I'm sorry, Your Honor, are you granting this motion then?
Yes, I am.
Okay.
Thank you. Motion for disclosure of expert witnesses.
On page 2, Your Honor, we would object to, I'm fine with name and address in a CV if they have one. I'll ask them if they have one. I've provided CVs on the people that I know have one. Under number 1, I'm fine with that. The subject matter of the expert's anticipated testimony, just a brief description of it, I'm fine with that. A summary of their opinions and conclusions, I'm objecting to that because, again, that puts me in a place of putting, making almost a record of what I believe their testimony is. And I would object to that because it's not required by law. And again, that puts me almost in a witness position. The basis and methodology used to reach those opinions, again, Your Honor, that puts me in a position of creating something. It's more than the law requires of the state. They have their names and their addresses and their CV if they have it. Number 5, I'm fine with any reports, notes, or testing results prepared by the expert. I'm fine with that, even though that's not required by law. Any documents, photographs, or data reviewed or relied upon by the expert, even though it's not required by law, I'm fine with that. I believe all of that is contained within the information they're providing. So I'm fine with it to the extent that it actually is provided by them. The experts' qualifications, including education, training, and publications, again, that I think falls under CD in subsection 1 and is more than the law requires. Number 8, any prior testimony by the expert in criminal cases, definitely objecting that one as far as it is extensively more than the law requires.
And if I could just address that point specifically, it was written very oddly. It's just, usually on an expert CV, it'll say, I've testified, in 15 criminal cases. I understand that this reads as if I want the testimony that they gave in those other cases. It's that I want notice of, like, this person has testified in Alabama, California, in 15 criminal cases.
It's not a requirement.
I'm asking.
If the state would be gracious enough to give that to the defense, if then that's fine. Otherwise, that's something that the defense can ask about, during cross of the
Yeah,
expert.
Your Honor, I think on the CDs, they have them listed, but I think I don't have a list of all that.
I've seen some that have it and some that don't, so,
I believe Dr. Nielsen and Detective Lawrence had that last week.
okay.
So to the extent that I have that, of course I would provide it.
Okay, so I'm going to sustain the state's objections to number 3 and number 4.
And again, Your Honor, just so the record is clear, I'm not challenging the court's ruling. In number 4 specifically, this is what is the methodology, if any, applied that the expert used? I'm not asking for the state to make up a methodology. It's, for example, when you have a insanity case, there are specific methodologies that are used by experts to make determinations. That's what I'm asking for when I say that.
Underlying data that they
The underlying
relied on.
data,
Yes,
that
exactly.
kind of.
But as for how they applied the methodology or what they used, that's something that you will find out when the witness is on the stand.
Thank you, Your Honor. And then for number 3, I contemplated that a summary of the expert's opinion and conclusions is just something that that expert would provide to the state and then would be sent to me. That's what I contemplated with number 3. So it's not something I'm asking Mr. Adams to create and form his opinion about what somebody else is saying, but just for them to say, this is generally what I intend to talk about, and that be forwarded.
The subject matter,
Your
The
Honor,
subject matter.
it just
which
briefly,
is number 2. Go ahead.
the law, there's a reason that the law has only the requirements of name and address when it comes to experts. There is another mechanism, and it's the appropriate mechanism to handle this, and that's to have a hearing. So that's why I'm objecting to all of that outside of what's required under the law, because if Ms. West wants that and defense counsel wants it, there's a mechanism by which to do that. We can have a hearing as to the experts, their qualifications, their backgrounds, what cases they testify. If they want to have that hearing, by all means, we can have those hearings to each and every expert. However, I'm objecting to all that is outside of what's required by law.
Right, and I've sustained your objection. Other than that, the rest of the motion is granted. Motion for discovery of all information obtained by the police from the Crime Stoppers program.
Your Honor, if there was any, that would be contained within the discovery that was previously provided, so I've got no objection.
That's granted. Motion for discovery of exculpatory and mitigating evidence. Has the state reviewed that motion?
I have, Your Honor, and the only word, just because I am very particular when it comes to words, just agents, generally. in
Which
possession-
paragraph?
Paragraph number 1, in the possession of its agents, and we're talking about agents of the state. Again, there's been a lot of talk about federal agents and stuff like that. I have no objection to disclosing any exculpatory or mitigating information, as well as all my requirements under 3914 Brady and its prodigy.
That motion is granted. Motion for discovery and preservation of recorded incoming telephone calls and dispatch radio communications.
I don't know if that's asking me for a response, because I don't have any ability to go back and preserve 911 calls 6 years later.
Ms. West, would you explain that, this motion?
Okay, I mean, again, I appreciate that it's been 6 years. There was a re-indictment in 2025. It's not the defense's responsibility to preserve and collect evidence. And so this is to ensure that everything as it relates to radio traffic, 911 calls, communications between officers, everything that occurred on November 11, 2020, which is the subject of this trial, regarding communications between law enforcement, is preserved and turned over to the defense as required.
Does that clarify things for the state?
I think this would be a proper motion and something that the city's attorney's office would have to reply to, and it would need to be served on Dallas Police Department. The extent that, and that's a motion for them to respond to. I've provided everything that I've received from Dallas Police Department as it relates to this offense back in November of 2020.
I'm going to grant this motion. All those calls and communications, hopefully the state preserved all of that. All right, is that the extent of the defendant's motions? Did I miss any? Ms.
Can I
West?
really have 1 second? 1 minute.
Yes.
If I may,
Yes.
the court has heard I believe was any agreements, motion for any agreements by the state. And I just wanted to kind of expound in the hearing with Marquise Conway, as it relates to the raspberries, Detective Lawrence several times said that Darvarius Moore was a suspect but was not charged. And I think our concern is that if there's any agreements or any actions on the state part with them not pursuing an indictment on someone in response to that person cooperating with the state, we would like to know that.
Yes, and that's envisaged in the motion and in my ruling.
Okay.
Any agreements at all, any concessions made to any co-defendants or suspects, that needs to be turned over to the defense.
And also, we just have an oral motion here that we have the ability to file additional motions if necessary.
Yes, you do.
That's it. Thank you.
Both sides there. All right, is there anything else? Does the state have any motions at this time? I think I ruled on the state's motions.
You rolled on ours in January, right?
Yeah, okay. All right. If there's nothing else, that concludes this hearing. Thank you. Devin Brown is next up.
written.
Yes. His attorneys are here. Does the state have motions on Brown that you would like me to consider?
Madam Clerk.
Yes. Thank you. All right, are both sides ready? Are both sides ready?
Ben's right here.
Thank you. Let's get on the record. This is cause number F2500177, style the state of Texas versus Devin Brown. Is that your name?
Yes, ma'am.
Will the attorneys announce their presence?
Elaine Evans for the defendant.
And he passed for the citizen accused young.
Relative state Texas. Tommy Adams, state Texas.
Thank you. And Mr. Brown is charged by indictment with the first degree felony offense of capital murder for remuneration. And today is the pretrial hearing. The defense has submitted a document titled Defendant's Election and Omnibus Pretrial Motion. Has the state had an opportunity to review that motion?
We have, Your Honor.
Does the state have any objections to any of the requests made therein?
Under subsection 9, under exculpatory mitigating evidence or evidence inconsistent with guilt, of course, we would comply with all of our legal obligations and obligations under 3914, Brady, as it relates to any other law enforcement agencies or prosecuting offices that are from the federal government. We, of course, have made requests to them for specific things as it relates to witnesses in this case, and we will turn over those things that we receive from them. As it relates to everything that's in our possession or an agent of the state, of course, we will turn over. I just want to make sure that's on the record. I, of course, heard that on the two previous defendants. Just want to make sure that I put that on the record as it relates to Mr. Brown.
All right,
As it relates to
that's granted.
Okay.
Go ahead.
And so 1 through 8, we're agreed on all those. Number 10, as it relates to disclosure and production of physical evidence, we're happy with defense reviewing and inspecting any and all physical evidence. We've just asked that they coordinate with the Dallas Police Department or the ATF to review it because it's not actually housed here in our office.
Okay, so the defense needs to review any or eyeball any physical evidence, make the scheduling, and meet up with the law enforcement or investigators and schedule a date to review that.
Yes, Your Honor.
All right, that's granted.
Number 11, my only problem there is on what the expert plans to testify on or about. I'm providing defense. I either have provided, and I believe I've provided all of the finalized reports, but I know I've also included drafts, but as far as what they're going to testify to is
I think that refers to subject matter,
just as far
on
as
what the expert plans to testify to or about. Subject
providing
matter.
just the reports. I mean, again, not me writing down and providing
No,
them. Okay. Then otherwise,
that's
okay.
granted.
Judge, on that issue, I just want to make sure, I'm trying to get no money. So we don't have no money to be trying to get all the transcripts from all this gang junk they were talking about the other day. I just want to make sure that the court will pay for a copy of those transcripts for my client, because I'm telling you, he ain't got no money.
You are retained, correct?
Yo, that was,
I understand. You can, we can talk about that.
well, I want to make sure that the court was well aware that he can't even report us, let alone, investigate.
Oh, you're doing this pro bono?
All
We
the,
are.
yeah, basically, because we didn't anticipate, we've gotten, I don't know how many terrors of discovery.
It's called terabytes.
Okay, it's a lot of information that has nothing to do with my client, so I don't.
Okay. I will pay for the transcript.
Thank you.
Thank you.
All right. All right, go ahead, Mr. Adams, yes,
Thank
go
you.
ahead.
As it relates to number 14, criminal histories of witnesses, we've covered this previously. I know Ms. Evans and Mr. Harris were both in here as it relates to criminal histories. I believe Mr. Harris was their first assistant when they had to go down and fight this whole deal. So I think he's very aware that we don't run law enforcement officers, but we will provide criminal histories of any witness that we intend on calling. And I will do my due diligence as far as asking officers about prior arrests and criminal histories that I intend on calling. But I know Mr. Harris put a good fight on that deal that I will work on it as the first assistant.
Okay. Yes, that number 14 is granted, and the state will turn over any criminal history information of its law enforcement officers or civilian witnesses.
Again, regarding the last paragraph on page 4, regarding any deal, immunity, promises, compensation, rewards, we will of course comply with all of our legal ethics and obligations under 3914 of Texas rules of professional conduct, case law, Brady, Giglio, and so forth. However, when it comes to things that may be in only the possession of the federal government, I am doing my due diligence to request all of that information or any potential evidence that is out there. And if I do receive any, I will, of course.
Do you mind if I ask you a couple questions?
Sure.
Do you have any idea where your family comes from?
Very little.
Have you ever heard of Been Verified?
No, I haven't.
So Been Verified has an obituary tool where you can put in the birth date and death date of people that you.
We would object to a complete and exact disclosure of the agreement, including notes, documents, recordings, electronic communications, and records reflecting the agreement. Again, my objection is not regarding the state and the state's actors, the state's agents acting on behalf of the state. It would my only objection is to those things to which I have access to. If I do receive them from the federal government, the U.S. Attorney's Office, the district judges over in federal court release them, I of course will comply and will turn over all of those things. But that is my only hiccup on that.
Yes, that's granted, so long as the state is making the inquiries and
Correct.
asking of the federal government, and if you do know that there are any agreements made by them relating any of these witnesses or co-defendants, then you will further investigate or at least let the defense know that this is information that is out there that needs to be developed.
Yes.
All right.
The only other thing, and I think this one can probably be held off on for now, and I'll leave that to defense counsel. It's number 19, a motion to suppress. We would just ask that they file a motion as to any hearings or motion to suppression hearings that they have or they won't have. But
Yes, if there's any evidence out there that you feel should be suppressed, then you need to file a separate motion.
Yes,
And
Your
bring
Honor.
that to the courts, yeah, bring that to the court's attention separately so we can deal with that ahead of time. Otherwise, that's granted.
Your Honor, we may just make a leave as well to file additional motions after we receive the notice of extraneous that's going to be supplied. We may have an additional motion as it relates to Mr. Brown.
You may file whatever other motions you feel appropriate.
Thank you.
And I'll have their motion, their notice of extraneous on Monday as well.
Okay,
Also, as it relates just so that it's on the record, inspecting the priors and stuff like that, I know Ms. Evans did share as well, and if they want to schedule time to come in and look at the priors and fingerprints and all that, by all means, they're in hard copy in my office.
okay, and available as a Monday.
Yes, ma'am. The only one that I don't have, as I stated on another record, or on the record of defendant White, would be his, Mr. White's Eastern District prior. Everything else I believe I have.
Okay. Okay, is that the extent of the defendant's motion?
Defense counsel did file them in all of their cases, but I think just for simplicity, my position on all of them, on all of the defense cases would be the same. And if the courts wanted to adopt that as cover all of his cases, I'd be fine with that.
Court will do that. Court will adopt all the court's rulings on this motion through the defendant's other cases. Okay. Other than the ones noted, the defendant's omnibus pretrial motion is granted.
Thank you, Your Honor.
You're welcome. Now let's go over to the state's motions and notices. State's first motion in limine, has the defense had an opportunity to review that?
Yeah, Your Honor.
Any objections?
No objection.
That's granted. State's second motion in limine. Has the defense reviewed that motion?
We have, Your Honor, and we have no objection.
That's granted. State's motion to require the defendant to be photographed.
Your Honor, we have no objection to that.
That's granted. Motion to disclose experts.
Your Honor, we have no objection, and should we have an expert, of course, we will supply the information.
That's granted. Okay, and then there's this agreed order.
I think that's covered by all of the previous motions that have been granted.
Right, I would say so. So the court will decline to sign that order.
No, I withdraw.
Okay, very good.
I have not filed it anyway, Your Honor.
Okay,
Madam Clerk.
yes.
Thank you.
All right, are there any other motions?
None from the state, Your Honor.
None from the defense.
Judge, the only, one caution, I don't know if they're claiming that my client is a rapper. It's not a very good one. I just want to make sure that we adopt those motions from co-defendants regarding the hearings on the gangster music and all that stuff.
Okay, All right, that's noted.
Thank you, Your Honor.
Thank you. There's nothing else. That concludes this hearing. Thank you. Where's this? So we're at lunch, so you can clear the court. We're at lunch, so clear the court.
Just so we're at lunch, y'all can clear the courtroom for us.
Shit, there we have it, man. You know what I'm saying? I think them boys cooked, man. I ain't gonna even lie. I think they cooked, man. And man, a lot of people ain't looking at this case like serious enough, but like if they convict them in the trial, man, I'm gonna tell y'all now, they convict them in the trial, the death penalty is on the line. The death penalty, they better try to plea bargain at 21st when they come back, you know, because they gonna have a plea bargain day where the lawyers can talk to each other to see if they want to, you know, come up with something, and the DA can, you know what I'm saying, if if that go through like that, then yeah. But they ain't finna just let them off scot-free and all nah. Because if they go to trial and they get convicted, just know that death penalty is up there. They just be thinking life sentence. They thinking life sentence on YouTube. Coffee Time telling y'all that death penalty is gonna be on the table. It's a capital murder, man. And then the cold part, it's a murder for hire. Check how many people then got killed for murder and hire in Texas. Coffee Time gonna give y'all the juice, man. These other bloggers, they don't know. They ain't been in no goddamn penitentiary. They don't know nothing about a penitentiary. They just knowing what on the outside, you know what I'm saying? But I guarantee you, if they convict them boys, they going to Pulaski unit. That's the last unit they gonna see is Pulaski unit to the Wilds unit. Yeah. See, them bloggers ain't telling y'all all of that. They ain't letting y'all know the real deal, because most of them don't know. They ain't been in that situation. They don't even know. You know what I'm saying? They don't know what it feel like to go out through the Golden Gates, man. You know what I'm saying? Your boys know when you go through them Golden Gates, you what? Let me see if somebody gonna get it. You free. See, them, they can't even tell y'all that. They don't know nothing about no Golden Gates. Only somebody that done been there. OG Percy speak on them because he know he been there. That's who you gotta listen to. That outside stuff is definitely interfering, man. That death penalty on the table for a reason. I'm telling you, they got capital murder on there for a reason. Why? Because capital murder carries the death penalty. That's what it carries. Simple as that. Capital murder carries the death penalty. Yeah, and they find you guilty in a trial, they can give you death or they can give you life. It's gonna be on them, not your attorneys, not your auntie, not your grandma, not your court cousin or whoever else the fuck you connected with. It's gonna be on them. See what I'm saying? And now I see a reasonable doubt too. I see them getting, man, from what the judge, you seen, she denied the other one, that other motion, denied it like a motherfucker. And yeah, he out of there. That means you cooked. I got enough evidence to prove other words. That's what that means. And then y'all heard the judge said, look, we got evidence that we ain't talked about or been discussed yet. We ain't trying to, I'm telling y'all, in the trial, man, ain't no telling what them people got, man. They done their homework. Man, text messages and that phone stuff, that's they stuff, man. That's the elite stuff. They the one created that stuff, dog. For real, for real. Bill Gates and all of them, they created that stuff so they can know what's going on, so they can keep up with each human being. Y'all really want to talk about that shit. That's why they can track your cell phone record. They can do all that. They gave you a fucking tracking device. Shit. And you think you finna get away and beat this after them people that got all of that evidence and stuff that they need? Hell nah. Hell nah. Hell nah. And I ain't gonna lie, if y'all go check the stats on murder for hire cases, when them people is getting took out unalived in Texas, I'm talking about Texas cases only right now. Go look and check what they did to them people that got found guilty in trial. And then y'all gonna see eye to eye with Coffee. Y'all gonna understand exactly what Coffee Time is saying right now. Ain't no other blogger gonna tell y'all that. If they tell y'all that, they done heard Coffee speak on it, because I ain't heard now one of them say what's the real deal with that death penalty. You know what I'm saying? All them saying life in prison or he gonna beat it. Shit, that death penalty is up there. I ain't gonna lie. Devin got, man, that death penalty on the table for him too. They talking about, he gonna get off this shit. Shit. They got enough evidence to get his ass too. And did y'all notice that motherfucker still got his goddamn dreadlocks? Yeah, that nigga letting another man do his hair in the jailhouse. That nigga letting a whole nother man do his goddamn hair, dog. That shit is wild as a motherfucker. That shit is the trip, man. This nigga ain't cut his hair yet. Yeah, for real. That's crazy, man. You better off with that shit, nigga. What the fuck these niggas got going on, dog? Man, that shit wild, man. That shit wild. I understand it's the county jail and you can still have your hair, but at the same time, you letting another man do your hair, dog. That's exactly what you're doing. You letting another man do your hair for some soups, motherfucker. Some ramen noodles, or some zuzus and wham, some cookies, nigga. Oh, yeah. Unless you got a goddamn man in there and that motherfucker doing your hair. Hey, it's gonna be a long road for you boys, man. Look, hey, what you do? Look, I'm telling you now, motherfucker, don't drop the soap, bitch ass niggas. Hey, but right now, y'all gotta worry about more than goddamn soap, though. Yeah, y'all gotta worry about that goddamn death sentence. Man, YELLABEEZY, he's so small, that nigga looking like a goddamn crackhead, dog. That nigga smile, that nigga chin smile. Y'all seen how that nigga was biting his lips like he on Exos. That nigga biting the hell out them goddamn bottom lip. Hey, I'm telling y'all ain't gonna hear that shit from nobody but Coffee, because Coffee ain't scared to speak on this shit. Coffee gonna speak on everything he see, goddamn. I don't give a fuck who like it and don't like it. Straight up. Y'all seen him bite them goddamn lips. That nigga nervous, man. He know his time is here. He know he fried. He know he cooked. That's guilty. That's that guilty look, man. If you ain't done nothing, you ain't finna be stressed out, losing weight and all that shit. Hell nah. You know you good. You know you ain't participating in this. But with that worry on you, you know you cooked. You know you cooked. You just trying to get, basically they fighting to basically get a life sentence. Cause I'm telling you now, when that 21st come and they go to plea deal, whatever, plea bargaining, life sentence is the less they can get, because that's what it carries. Death sentence or life sentence. They're not gonna get no 25 years, no 40 years, no 80 years. Life sentence or death sentence. One of the two. You're gonna plead out to one of them two right there. So basically, when people back against the wall like that, they gonna go to jury trial. Hell, if you're gonna give me a life sentence, you might as well give it to me in trial. You know what I'm saying? You might as well give it to me like that. Shit, I just ain't gonna sign for no goddamn life sentence. I don't give a fuck if I'm guilty or not. Take me to trial. You know what I'm saying? If I got a way out of it. If I don't and I know I'm cooked, I still ain't plea bargaining for that life sentence, niggas. You know how it feels to just sign your motherfucking name on the paper saying you signing for your life sentence? Fuck no. Hell no. Fuck that life sentence. Hell no. I couldn't be caught in that position that they in. You know what I'm saying? And it all comes down to, if when you want your work done, do your own dirty work. Don't stop telling people, stop texting people, stop letting people that rap pop up on your live and rap a song about the dead. This nigga still alive. He's still alive. I'm gonna do a live on it too. Did Trap Boy Freddy set YELLABEEZY up? Yeah, you got a lot to do with it, nigga. You was motor mouth, nigga. You was the motor mouth behind the whole operation, dog. The whole operation. He was the motor mouth. Everybody knew the Trap Boy was talking too much. Trap Boy was talking too much from the moment he hit the freeway. And now we all know the feds is involved. Y'all heard what that judge and them said. They waiting on the paperwork from the Federal Bureau, and that they working together. In case y'all ain't understand that or catch on to it, they working together. So I don't know how this case gonna turn out. Like seriously, it could turn out any which way. Any which way. I'm just being real about it, because these other they not gonna touch on that. I promise you they not. They gonna tell you everything else that was going on, and then you gonna go you hear somewhere else, you gonna hear it different. You know what I'm saying? Listen at what the people say. With the not the YouTube people. I'm talking about them people, them white folks said that. That's the system that they caught in right now. That's the white folks system. You want to be real about it? That's the white folks system. That ain't the black folks system. That ain't the Mexican system. None of that. The white folks run that system. From the courtrooms to the penitentiary. Understand that. I'll be back later on with some more, man. I'm up out of here. Appreciate y'all tuning in Coffee Time.